all here and be a part of it. I know for many of you, this is your first time to attend a compilation, revision, and correction committee. Is that what it's called? Compilation, correction, revision?
It doesn't have correction in there, but it's close.
There you go. And it's a meeting that takes place once a year. It is incredibly important because what we do here today is basically draft the code, which will then be printed and distributed around the entire state. It is the law, and so we are basically putting together the law. Unbeknownst to me, when the session concludes, there are certain corrections or I guess conforming is probably a better word, revisions that have to take place. Sometimes a comma's not in the right place. Sometimes a number's not correct. This committee does not have the power to change the content or the substance of a law, but we do conform them. For example, sometimes there'll be a House bill that is passed and signed at 12 o'clock, and there's a Senate bill that does the same thing that's signed at 2 o'clock. Which one of those controls? Well, it's the one that's assigned, or that is signed the latest. So on and so forth. So that is what this committee is assigned the responsibility of taking care of. This is a joint committee. I will note we have a quorum. The joint committees require at least 4 members from each chamber. And as I see, I look around the table, we have met that requirement. So that's kind of an overview of the committee. Basically what we do is listen to Ronnie Frith tell us what we're supposed to do. So I'm going to turn it over to Ronnie and let him run the meeting.
Okay. This term, we have more new members on the committee than we've ever had. We only have 3 returning members. We have Representative Cockerham, Representative Reynolds, who I thought, oh, there he is, and then the Speaker, and Senator Branning from the Senate side. So we have a lot of new members. The Speaker has briefly gone over the function of the committee, but what I like to do is give you a little bit more detail so y'all know what in the world y'all have been appointed to, what we do, and certainly y'all can ask questions either as I'm talking or later. But the committee, this committee is a joint committee like the Legislative Budget Office and the Peer Committee. It's created by statute, and it was created in 1996. And the Speaker, given the name of it, it's the Joint Legislative Committee on Compilation, Revision, and Publication of Legislation. So it's a big mouthful. We just call it the Code Committee because that's primarily the part of the type of legislation we deal with. The 2 primary duties of the committee are, first, to provide for the publication of the laws of a general nature enacted by the legislature each year in the Mississippi Code, and that is done, the publication, by a publisher that the committee contracts with, which it currently is LexisNexis. They have been our publisher since 1998, since the contract was signed with them. It's been renewed a number of times since then. The second duty is more administrative, but the committee doesn't actually do this, but it's provide for the distribution of code sets and annual supplements to state and local subscribers that are entitled to get it under the statute. I'm going to show you that in a moment. We call them the public subscribers. Now, some history before 1996, who did this? Well, the Attorney General and the Secretary of State jointly signed the contract, and the Attorney General did the revision, which is what the Speaker said, take the laws and put them in the code, and the Secretary of State provided for the distribution. Well, when the law passed in 96, all those duties were turned over to the committee, and so there are 2 co-counsel, House co-counsel and Senate co-counsel. I'm the House co-counsel, and Ian Jones here is the Senate co-counsel. This is his first year to do it. Bubba Neely did it for a long, long time, and he and I were the original co-counsel. So we do the revising of the laws to put into the code, and the Reference Bureau has been assigned the duty of providing for the distribution, keeps up with the address list, and you've got a lot of new officials coming in this year also that get those. Okay, the committee was created primarily to provide the legislature with official and direct input into the publication of the laws that it enacted, which it didn't have under the previous arrangement. The Attorney General primarily is the one that decided where everything went in the code. The legislature, they'd listen to us, but we didn't have any official input. We were only one of 3 states that didn't have any input, and so Speaker Tim Ford introduced the bill, and it surprised me that it usually takes a few years, but it passed the first year. Now, the contract was still in effect for 2 more years until 1998, and the committee put out an RFP, and the competition was between West Publishing and Lexis, and Lexis was very close, but Lexis won the bid. And Lexis, I will say this, when West lost the bid, they produced their own code at great expense to them. I don't know how many people use it, but they have it available. And so we have not put it out to RFP since 1998. One of the reasons is we have a good working relationship with Lexis. It's a major thing to transfer to another publisher, which we found out in 1998. And also, if you put it out for bid, this question's come up before, if you put it out for bid and West has their own code, are they even going to bid? And if they don't bid, then could Lexis just set their own prices? And Lexis has said, well, we're always looking to maximize our revenue. So that's one reason that we have not have not done that with a new RFP. Okay, now this is important. Committee's duties. The committee has no authority to, the committee is not involved in the publication of the general laws, the local and private laws, or the administrative code, of agency rules and regulations, or the journals. The Secretary of State does all of those. The committee's duties are limited to preparing the general laws for publication in the code. The speaker said this, the committee generally meets 1 time a year. This is our annual meeting. And during that meeting, they typically consider the items on your agenda, which you see. I've told you the committee staffed by 2 co-counsel. I've been counsel from the beginning, and Ian is the new Senate co-counsel. We are the liaisons with the code publisher throughout the year. We get a lot of questions from them, and for some people that just wonder how the statutes get into the code, the Lexis editor, we have a very good editor named Linda Scove in Charlottesville. She prepares spreadsheets for us, and we have had 3 so far. We're going to have a 4th one because some of the things that passed at the last minute in early October. But we go through, and primarily Ian and I do it. We answer the questions for them and approve the section numbers and the other internal changes. We get input from our colleagues who know more about it in the House and Senate Legislative Services Office. That duty was formally performed by the Assistant Attorney General, who is designated as the reviser of statutes. Now, the committee's authority, what can the committee do? The committee is an agency of the legislature, but it can't do everything the legislature can do. It's not a legislature of last resort, as Bubba Neely used to say. The committee has authority to change or correct language in the code or in bills, but it's rather limited. The committee can only make minor, non-substantive changes in language. It's not authorized to rewrite language in the code in any way that would change the substance, because if it did, the committee would be legislating, and that would be an unconstitutional delegation of power, of the power to legislate, to a body that's less than the legislature itself. Examples: the committee cannot delete a sentence. The committee cannot rewrite a provision to change the meaning. Now, the committee can correct errors, and that's one of the items that's on the agenda next. But they have to be manifest, patent errors. And you can't change the language to read another way based on what somebody tells you was intended. Oh, we meant this to be this. The error has to be manifest, and over the years we've developed a standard for determining that. We look at it and say, you pretty much have to look at it and see that it's wrong. And you pretty much have to look at it and see what it should be changed to. And I'll tell you this because you're going to see it in a second, but if there's any doubt, we don't make any change. We don't recommend any change. If there's any doubt that it changes the meaning, it's been going along like that for a while, we just say, don't change it. We also can't change anything based on the consequences. You know, you say, well, that's the language we meant, but we didn't intend for it to do that. Well, the committee can't get in and change that either. Now, the committee, and this comes up every year, the committee sometimes says, well, there's an error in this appropriation bill. Can you change it? What about this bond bill? No, because the committee has no authority to change anything in any bill that will not be codified. Like appropriation bill, bond bill, local and private bill, it can only make minor changes in legislation to prepare it for publication in the code. In your handout, and I'm going to do it real quickly because I've summarized it already, but I wanted y'all, especially as new members, to see the statutes. These are the key statutes that create the committee. And I've got the long title of the committee circled up there. But like Section 11103 creates the committee. It's a joint committee, half House members and half the Senate, 14 members. The Speaker and the Lieutenant Governor alternate annually on May the 1st for the chairmanship. And so the Lieutenant Governor will become chair on May the 1st. But the Speaker is the chair in the even numbered years, and the Lieutenant Governor in the odd numbered years.
Is there some sort of message in that?
That'll be between you two.
That the Speaker does even and the Lieutenant Governor has odd?
Council says no comment.
Never mind. Go ahead.
Y'all might want to talk about that. The committee staff, that's a statutory requirement that we have two staff persons, one House, one Senate. 11107, I've told you the check mark is the authority, well, the duty to have a contract with the publisher. 11109 at the bottom of page 30 is what I told you. If you look at that lead in preparing the acts of the legislature for publication in the code after the adjournment of each session and without altering the sense, meaning, or effect of the acts, the Joint Committee is authorized to do the following. And so that's why we have interpreted to say it's only legislation that will be codified that the committee can exercise these powers. I put that error by number C, correct manifest typographical and grammatical errors. That's the next item on the agenda. And then the last one, paragraph L, is probably the major thing that y'all do. People have asked me, what would happen if you didn't meet? Well, the code errors wouldn't get corrected, but you might could live without those. The prices couldn't be increased. There's a gradual price increase most years. But like the Speaker said, y'all may not realize it. Sometimes you do, sometimes you don't. Y'all are amending the same code section in several bills in different ways. And there's a code section 1-3-79 that says basically the latest effective date controls, or if they're the same effective date, the latest signature date by the governor. What that means is one version of that code section in one bill is going to wipe out all the other versions. And so it doesn't mean that y'all are necessarily being sloppy. Before 1996, you absolutely had to go to conference to conform everything into one bill, or something was going to get wiped out. With this authority in that paragraph L, you have the authority to integrate or merge the multiple amendments as long as they meet certain criteria, don't conflict, and don't conflict in substance or the intent of the legislature as indicated by language in the bill. So now you don't have to merge everything. You can vote on this one separately and that one separately, and you may want to do that. One's controversial and one's not. But this is what this committee does, is now you come together and put those things together for so that all the language and all of the amendments goes into the code. And that's called integrating the amendments or merging the amendments. Okay, we'll just flip over to 1-1-11. Now it's been amended, and I've attached it at the back, the bill. But 1111 is the list of what I call the public subscribers. It's mostly state agencies, state officials, and a lot of the local officials. They get the sets of the code and the updates, the supplements every year, distributed to them by our by Lexis, but the Reference Bureau gets the coordinates with that. And Lexis, I'll tell you in a minute, we pay them for those sets, and we don't pay Lexus for anything else. It's just all the dollars we give to Lexus are for buying code products. And then 1157, 1158, 1159, and 1162 are duties of the committee to purchase updates for the sets that they have. Now, there's one thing in there we're going to talk about later. It's on the agenda about the CD-ROMs. CD-ROMs have kind of gone by the wayside, and there's going to be a proposed amendment to take that out of the contract. But I'll tell you more about that in a minute. Okay, that is the statutes. Now, next in your packet, just very quickly, the committee has a budget. It's an appropriation bill passed this year, 1692. On the third page, there's a line item of $400,000 for the committee. That, as I mentioned earlier, that $400,000, it started out as $300,000 in 1998. And there's usually a 2 to 3% increase in the code products, which is on the agenda later. Anders Ganton with Lexus will present that to you. But it finally got up close to the $300,000 and it was raised. That is solely for purchasing code products for the public subscribers. It doesn't pay for your coming to this meeting. It doesn't pay for any staff. It doesn't pay for any stamps. It doesn't pay for anything. We don't pay Lexus for their editorial duties. We don't pay them for their publishing duties. We don't pay them for shipping. Basically, they do it for free, but for exchange of being the official code publisher and the agreement that we will buy a certain number of sets from them every year. The $400,000 is a little bit high, but what happens is it's a cushion there because we get people that, like the new officials come in and they say, well, my code's half gone. What do we do? Well, technically, the predecessor was supposed to buy it, keep up with it, but they're gone. We can't get it from them, so we buy them a new set or replace the volumes that they're missing. So anyway, they have that duty. Now, I'm going to go over this real quickly, but the next thing in the packet is the contract. The contract, as I told you, was executed in 1998. It's generally renewed for 4 years. It was renewed for 2 years in 2010 and 2 years again in 2012, but other than that, it's been renewed for 4 years. At the back of the contract, I've attached the renewal letter. The latest renewal was in 2018 for 4 years. So the contract is in effect till October 14th, 2022. Very quickly, I'll just point out, okay, the editorial duties of the publisher in Section 1. The publisher has to bear all the expenses in that arrow that I have there. All expenses, we don't pay anything even for shipping. If you flip over through the contract to page 6, the publication duties. They do the supplements, they do the replacement volumes, which are your new hard main volumes. And then at the top of page 5, I put grid sheets. That's what we call them, the spreadsheets that we do in the summer, really normally in the fall this year, about where all the laws that y'all passed, where they go in the code. Y'all don't really have a direct input into that. You could, but probably wouldn't want to. But we review, Ian and I review those throughout the last few months, and we submit that to the publisher. We normally have everything ready a few months before this meeting. Of course, y'all were meeting right up until early October. And so we're going to have everything in the code because of our editor really getting on it and us working really quickly, except for those 5 new programs that y'all created. They will be they'll be official. They'll still be the law, and Lexus will probably put out a special supplement for those new programs, but all the other laws that were passed up through early October will be in the supplement that come out. If you look at the 2.5 on page 8, the Advanced Code Service, this is like an interim supplement that you get 3 times a year between the supplement. So the special supplement we get for the those laws passed in October will either be in there or be in a special supplement in addition to that. Look over on page 15. Page 15, the prices. The prices of the code were set in 1999, and they've gone up each year. The prices are done by this committee. Y'all will have a vote on that. The publisher cannot change any prices without permission of the committee. If you look on page 16, government purchases, what they charge to the private sector, we get a 50% discount. 50% discount on all the prices. I think that's everything in there. The term of the contract that page 20, 10.1, that was amended, which is attached to the end of this. It was amended in 2002, basically to allow it to be renewed for up to 4 years. Like I said, it's always been in increments of 4 years, except in 2010 and 2012. Okay, that is a quick overview of the history, the powers and duties. Mr. Speaker, does anybody have any questions
Anybody
now
have any
about
questions about any of that? The Lieutenant Governor has a question.
that? Yes, sir.
Yeah, when we were doing this Secretary of State's office, we asked a number of the sheriffs and DAs if they wanted copies of the books, because they were basically just piling them in a corner somewhere. And so a number of them, I think it was about half of them, decided not to take the books. So we've got a requirement in the code that they have to execute an agreement in order to get the books, right? And are you doing that? Because a lot of them didn't want them. Most of the ones younger than me, anyway, are going online. And so the books are not really being used at all.
What were you looking at right there that says?
This is your
about the
statute,
agreement?
the amended statute that you had on,
Yeah, I just wanted to be sure what.
it says in there that the joint committee shall execute the agreement and forward it to the office holder for execution. They shall not deliver or provide delivery of the code to the office holder until the executed agreement is received by the committee.
Oh, yeah, we do that. That is for, they're supposed to agree to use that for government use only and not for private use. So we give them that. Now, this new language here, it was amended on line 286. It's actually in the statutes at the very end. It's the new bill that passed in 2020, line 286. This is not to the state agencies, but any elected state officials and state district officials and legislators don't get it unless they request it. Now, we don't have the same language, Mr. Lieutenant Governor, for the rest of the recipients, the local officials.
Well, we did that anyway. They had to execute something anyway to say they would keep it, whether it be the sheriffs, the DAs. I think the most that wanted it were the judges, actually. A number of the sheriffs didn't want it at all, and the DAs was about split. So what I was going to ask is, could you make sure that they want this before we ship it out, before we deliver them?
If there's authority for us not to do that, we could do that. That language I read to you there is the case for the state elected officials, district officials, and members of the legislature. If you go to the beginning of the statute, it says they get it and it's shipped to them.
Right, and when we checked with them, though, they didn't want them. They didn't want them shipped to them. The only thing I'm saying is, if they hadn't executed this agreement, that's the way in which you get around not sending it to them. If they don't execute that agreement, you don't send them one, right?
Well, like I said, the agreement is not to receive it or not. The agreement is to use it for government purposes and not for private purposes.
Right, so the back end of that, if they don't sign it, you wouldn't send it to them, right?
That would be correct.
So you have an agreement on everybody that gets this?
Well, the Reference Bureau does that. They have, I'd have to check with them and see, but yes, they
I think
know
I
to do
would, and
that.
I'm gonna put this on our list for the Senate anyway to look at. I know a number of the ones don't want these books anymore. They use the internet and they're just stacked in the
Right,
corner somewhere.
sure.
There's
I
no need for the
understand.
state to have to pay for that.
Right.
Particularly if they're not using it. Will you check, please, and I'll let you keep going, on how many of these, make sure we've got the executed agreement on every one of them? The ones that don't send it, obviously, they say, I'm not executing any agreement, I don't want it, which is fine.
Right, okay, we'll have
Thank you.
people in the reference bureau look at it.
Thank you. All right, we'll move on to item 2 now, correction of errors. This
Okay.
is this page right here, is it not?
Yes, sir, it says Mississippi Code Errors 2020. That is one of the powers that I told you is in that section 11109, is to correct manifest patent errors. And where we get these, people, I have a code error file, and people tell me about it. I find it when I look through the spreadsheets. Our editor, Lexis editor, has found them. Our proofreaders find them. Sometimes members tell us, or agency people tell us. What I've found works best, instead of handing out all the errors to you and have you look at it, is do this list. And what I try to do, instead of just change this to that, I try to show you the context, if it would help, and a little explanation in parentheses underneath, but just giving you some examples, like the third one, 275713 in House Bill 866. Throughout the bill, they were having, and I can't tell you, I've got the copies of everything if you want to look at it, but I can't remember exactly. It was distributors of, I think, petroleum products or something. Anyway, they deleted Class A everywhere. In one place, Class A was still there. It was obvious from the context that Class A should be deleted. So I put that on the list. At the end, 29513, there was a 2 in subsection 2 and 3, but there was not a subsection 1. If you look on page 2, there was a reference to the U.S. Code. It was 18 U.S.C.S. 826, talking about military judges. There's not an 18-826. It's in 10-826, so that was a manifest error. At the bottom, 4126-101, there was a new 3 added, but the existing 3 and 4 were left in, so now you have 2 subsection 3, so we're renumbering those. I won't go over those. I think, Mr. Speaker, what you've typically done is given them a few minutes if they have any questions.
That is correct.
So
I will give everyone
I'll
about
just pause
3
for a moment.
minutes.
If anybody has any questions on any individual ones, I will be glad to answer.
I would ask everyone to just kind of peruse this for the next few minutes. And if you have questions about any of them, we'll let you ask it.
While y'all are looking, I will comment. None of these changes affect the substance. I felt like they were manifest errors that I could tell they were wrong, and I could tell what it should be changed to. And if somebody told me something should be changed based on intent or whatever, or if it didn't appear to be clear that it was an error or what it should be changed to, I didn't put it on this list. So because of the authority of the committee to do this, it allows allows y'all to clean up things. That if you look at that, I put, after the section number, I put a bill number, if it was in a bill this year, and by far, most of them are in bills this year, so we're able to clean up little things that otherwise would be kind of messy in the code, or maybe even incorrect. There were some, over near the end, there were some code section numbers that were put in the bill itself, and they were duplicated, they were out of order, they were clearly wrong from the context, and if the committee didn't have this authority, it would be wrong in the code. So
All right, it appears to me that most everyone is through. Are there any questions about any of these corrections? Ronnie, let me just say that it's very helpful the way you, for me personally, the way you crafted this. You tell us what the changes are, what it said before, what it's proposed to say now. I think it's very efficient and very helpful for you to do that. So thank you for the way that you've structured it.
Sir.
Lieutenant Governor says he has a question.
Can you look
Yes, sir.
at 41-131-1?
Yes, sir.
Where did that come from?
That was the right to try bill that allowed experimental treatments to be used when somebody was a terminal patient. And that was, I think it says experimental, I've got it here, I'll look it up, but I think I can remember it. Experimental or investigational drugs could be used, and that was added to be added to the bill in about 12 places before the word investigational drugs. And when you read it in one place, that got left out. So from looking at it here, you'd think, where in the world did that come from? But when you look at the bill, it's all throughout the bill, added to the right to try, what it's called, where certain experimental or investigational drugs are allowed to be used in terminal for terminal patients.
So this is added to before the words investigation drug, but it was added in front of all the others?
Yes, sir. The legislature added it in front of all the others,
All right, that's good.
and it might work if it were missing, but it clearly should have been in there because it was in there every other place in the statute and was omitted there, probably by mistake.
All right. Seeing no further questions, I guess we need to have a motion to approve these. Is that correct?
Yes, sir.
My memory correct?
Yes,
All
sir.
right. Do I have a motion to approve these corrections? And a second. All right. All in favor say aye. Aye. And the motion carries. All right. Next, we have the multiple amendments to the same code section. I think Ian is going to handle that, so I'll recognize him.
I'll be covering this bigger booklet that you have in your packet. The first page is just the guidelines that govern how this committee operates with respect to code sections amended by more than one bill. The speaker and Ronnie have pretty much covered those. But I'll draw your attention to the bottom of page 1. That's pretty much the meat of it. The point of merging amendments to a code section is to make sure that the code section looks the way the legislature intended. And if both of these requirements at the bottom of page 1 are met, then we can presume that the legislature intended that all of the amendments take effect. So the amendments need to be standalone, not overlapping or conflicting. And secondly, there needs to be no express legislative intent not to merge. If either one of those are present, then we can't presume intent to merge, but otherwise we do. So that being said, we'll go through the code sections that require merger. That list is on pages 3 to 6 of your booklet. I won't be talking about every section on the list because these are just the sections that have been amended by more than one bill, but only some of them are sections to be merged. So I'll be skipping the ones that aren't to be merged. If anybody has any questions about those as we go along, I'll be happy to answer them, but in the interest of time, we'll just discuss the ones to be merged. Starting on page 7, first code section is a newly codified section 27.7.109, and that was section 11 of Senate Bill 2772, which was later amended by a House bill. But then after that, Senate Bill 3053 amended 2772 and included the original section 11 as it was originally. It did not incorporate the amendments from House Bill 1748. So in order for those amendments from 1748 to take effect, we will have to merge those. And also, in your packet, the parts of the code sections that are highlighted in yellow are the parts that will not take effect unless the committee votes to merge. It's the way that it should look once it is merged, but the yellow is what won't happen if you don't vote to merge.
In other words, we will be asked to approve what's in yellow.
Exactly.
That's going to be the
Yes.
vote at the end of this presentation.
The next section, page 7, 2771.301, this begins a list of a good many sections that are amended by House Bill 917. What 917 did was to add light spirit products to beer and light wine to have them regulated the same as beer and light wine. So that's really the only thing 917 did. So everywhere in the code that beer and light wine appear, we also added, and light spirit products. Sometimes another bill would delete certain language that had beer and light wine. Obviously, in that instance, we wouldn't add light spirit products in those places. So anytime 917 appears, the point is just to get light spirit product in the right place. If you look at 277301, you can just thumb through and see the places where light spirit product appears. It's a good many places. The next one is on page 10, 4126.101. For this one, Senate Bill 2311 governs. It's the controlling bill. So the amendments from 2674 would be wiped out without merger. And you can see all those starting on line 101. Then on page 12, you have 45.9.101. Senate Bill 2225 has an amendment there on line 175. That's going to be there regardless. And if you turn, you have light spirit product language on page 23. Next, we have section 6321.15. This is the first of a few bills where the bill that's controlling doesn't actually take effect until January 1st of 2021. Because of that, the code section is tiered. You've got the section as it appears before the new year, and then the section as it appears after the new year. But what would happen if you didn't vote to merge is, once the controlling bill takes effect of the new year, the language from before the new year would get wiped out. So you can see that. Page 4. Page 40, you get the language in the non-controlling bill. That's where it starts. Then on page 42, we have section 6717. The language from 2253 governs. The language from House Bill 1087 would be wiped out without merger. Certain deletions there. 67118 on page 43. You've got more light spirit product language that would be wiped out without merger. 67137. The language on page 49 would be wiped out without merger, that new paragraph Q. 67141 is another tiered bill. House Bill 1088 goes into effect at the new year. So once you get to page 53, the second tier, the later tier, the highlighted language on page 56 would be wiped out without merger. That's language from the native wine bill. Same scenario with 67145 on page 60. On page 61, you've got that clause at the top of page 61 that would be wiped out without merger. $67,151. This is amended by multiple bills. Senate Bill 2253 actually incorporates the light spirit product language in it, but it still has to be merged because 1088 controls. So again, you've got the different tiers. It's a very long section. If you go to page 79, that's the second tier. And the language that would be wiped out is on page 81, 83, 87, 94 and 95, and that's all. I'll give you a minute to look over that one. $67,177 on page 97. On page 98 is the language that would be wiped out. That's tiering that particular paragraph C, and that is from the native wine bill. And then 6739, more light spirit product language will be wiped out without merger. 67,369 starting on page 102. Again, it's only light spirit product language that you need to merge in order to include. Page 106, section 71,5,353. The language that would be wiped out is on page 121 to 122. That's language from Senate Bill 3051.
All right, that it? Thank you, Ian. Questions on any of that? Yes, sir. Senator Fillingane.
Thank you, Mr. Speaker. On page 49, and I think it repeats several different times through here, I'm just curious, when we're talking about prescribe and charge a fee to defray the cost of the shipping of the beverages, did we not address that? Or did we just address it in different ways and you're trying to pull it together so it's uniform?
That's right. This paragraph Q was in a bill. It's just a bill that would get wiped out by a more recent bill if it weren't merged.
Gotcha. Because I thought we remembered discussing some of those issues.
It was passed.
All right, thank you.
Other questions? All right, thank you, Ian. I don't see any. Need a motion to approve these changes. All in favor say aye. Ayes have it. All right, changes are adopted. Next, we have the approval of prices for code products for this year. Anders Ganton is with us. Always good to see him each year. Ronnie, do you have anything to add, or we just turn this over to Anders for presentation?
Just a couple of things. Like I told you,
I'm sorry, this is a letter
yeah, it's a
that you
letter
have here in
from
your packet.
LexisNexis dated November 15th, 2019. Under the contract, the publisher is required to submit a list with the proposed prices and also the proposed replacement volumes, which will be the new hard volumes that will be coming out. Supplements got pretty big. And if you look on the second page on the back, I printed it on both sides. Those are the proposed prices for the next year. And you see in the second column that we have a 50% discount. So the price that the general public pays, private sector pays, we have 50%. Anders will present the reason for that and what it's based on. But this is something the committee does every year. And they almost every year. Last year they didn't anyway, they didn't do it last year because of some mess ups here, and that they did, and they just decided not to charge us for it. But every year, and it's usually 2 to 3%, and I think that's what it is this time. So Anders, if you could explain to us the amount of the increase and the reason for it.
All right, how do I turn this on?
It's on. Go ahead.
Oh, very good. Thank you, Mr. Speaker. And I know some of you have seen me before. I think this is my 15th year coming here, believe it or not. So very briefly, you will see in my letter, we're asking for a modest price increase, about 3%. That's to account for things like increase in paper costs, staff costs, benefit costs, all of that. As always, we want to make sure that the code remains as affordable as possible, which is why we try to keep the price increase to a minimum. The producer price, which is a benchmark that we go by, usually industry-wide, increased by about 4.5%, so the price increase is lower than that. An average user will see an increase in cost of about $15, and half of that for the government.
Thank you, Anders. Questions of any of the committee members? All right, I don't see any. So to have a motion to approve the contract. All right, all in favor say aye. Aye. Opposed, nay. The ayes have it. Thank you, Anders. Good to see you again. Next, we have the proposed contract amendment to discontinue CD production. Ronnie, I'll turn that over to you.
This is a continuation. Oh, excuse me. It's here.
This is this piece of paper, by the way.
Piece of paper with the yellow highlight there that says amendments regarding the CD. At the last meeting, at the meeting last year, there was a request from Anders to discontinue the production of the CD, which was required by the contract in 1998. He'll address this after I give you the basics, but apparently there were only 2 paid subscribers last year, and so it's just not worth it to them to even have to produce it. So we looked at the contract to see if we could do it last year, and we found out that it also was mentioned in the statute, so we had to get the statute amended. And a bill was introduced by Senator Bryan, and it died in committee, but Senator Doty stuck his bill into another bill, so it passed. And it's that bill that you looked at the end of the statutes that has 1-1-1-11. It took the language out that required a CD. So this is the proposed amendment to the contract to delete everywhere it talks about a CD. That item number 1, there were 3 sections. Well, one was an exhibit, but section 2.6 and 2.10, that should be deleted in their entirety. I did a search to find wherever CD-ROM appeared and struck it out, or I may have had to add a word or two, like the word or something that was in a list. But what this would do is no longer require Lexus to produce a CD for purchase. Just take it out of the contract, amend the contract to do that.
Questions?
And Anders, do you want to say anything about it, just briefly?
We have a motion by the Lieutenant Governor to approve it.
Okay, well,
So,
Anders, if they're already ready to vote, like they say, vote, 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 you know. So.
there you go. Yes, sir.
May or may not be online. It's not particularly the CD-ROM, but Mr. Anders maybe can answer. The replacement volume price is $22.75 to the state, so that's an individual book that we realize needs to be replaced. Is that what I
correct,
understand?
Anders?
And a full set of the code is $229. Do we differentiate if somebody requests replacement volumes that exceeds the price of the code, that they're automatically going to send them a new code instead? Because I think that was addressed earlier when they said someone comes in and needs replacements because the prior sheriff or the prior chancery clerk didn't update the pocket parts. I just want to make sure we're not sending 16 replacement volumes that exceeds the price of a new code.
I can address that. The people that handle that are Diane and Maria in the Reference Bureau, and they always check with me first to see what they should do. What happens is a sheriff or it's more often than not a local official where a new official has come in and their set is decimated. You know, it's just been carried off. And so they say, I need a new set of the code. Well, what I always ask Maria and Diane to do, I say, call them back and ask them to give you a list of every volume that you have. And also on the spine of it, I don't have one here, but it shows when it was last replaced, because you might have volume 10, but it's not the most recent replaced volume. And then we see how many they need. And if it's more than the cost of the code, we get them a new set of the code.
Thank you.
All right, we got a motion. All in favor say aye. Opposed, nay. The ayes have it. Motion carries. Next, we have the update on litigation regarding the copyright of annotations. Ronnie?
Okay, I think the Speaker and Representative Reynolds are the only ones that have heard this, but it was an interesting set of circumstances. In 2013, a man named Carl Malamud in California, Public Resources Organization, decided that the law should be free. And he meant all of the law, not what y'all passed, but the annotations and everything that's in the code ought to be free. And so he scanned our entire code, put it on a thumb drive, and also put it on his website. He did that for 5 other states in addition to Mississippi, Georgia being one of them. And we asked the Attorney General, who had an expert there, I'm not sure if he's still there now. Larry Schimmel's expert on intellectual property, and he was ready to file a lawsuit, but Georgia did it first, so we filed an amicus brief, a friend of the court brief for non-lawyers, supporting what Georgia was doing. And so it went to trial in the district court in Georgia, and Georgia won. They said that the annotations could be copyrighted, and that Carl Malama was violating his copyright. He appealed it to the 11th Circuit Court of Appeals, and they reversed the district court, which means that they could not be copyrighted. And so they requested the Supreme Court hear it through a writ of certiorari, and only about 1% of those are granted by the Supreme Court, and surprisingly, they decided to hear it. And in December, they came out with an opinion that upheld the circuit court, which was surprising. It was a 5-4 decision, and basically they said, at least with regard to Georgia, that you cannot copyright the annotations. Well, what does that mean? If Lexis, we have a contract with them to produce the code, but they do they could produce the statutes, but the unannotated version, which they do have online, free for anybody. But are they going to spend the time and the money and the resources if anybody can just copy it and sell it for themselves? So, Anders and I have talked about it. We think there's some things that may be unique to Georgia. I'm not going to get into the legal analysis of what the court said, but it's an interesting case. But in any case, I wanted Anders to address the possible effect of this on the status of our contract, and if they don't have the protection of the copyright, are they going to continue with our contract or what? So Anders, would you address that for us, please?
Yes, and very briefly, and I'm happy to take questions as well, of course, because it's a fairly intricate matter of copyright law. And LexisNexis was also an amicus in the case. We were certainly disappointed by the court's ruling, but our assessment is at this point that because of the uniqueness of how Georgia does things, among other things, they actually vote on the annotations and everything that's included in the code once a year, which gives a stronger link to the legislature. So at this point, our point of view is that the ruling applies to Georgia only. Now, under the contract, we are required to register the copyright for the Mississippi Code every year. The Copyright Office is notoriously slow in getting back to us. They usually have a backlog of a year and a half. So we will see what kind of pushback we will get, because they tend to take a broader view on things. So it is quite possible that when we have this meeting next year, we will come back, and certainly I will keep Ron informed in the interim and ask for possible modifications whereby it would be made more clear that when it comes to the involvement in the annotations, the legislator's involvement is a very light touch indeed.
I will comment on that. What the court said, without getting into the detail, is that a judge or legislator or any public official that makes law or interprets the law cannot be an author for the purpose of the copyright law. And that doesn't mean just the statute. That can mean other things like annotation or syllabuses in the court reporters, things like that. And so what they said is, because in Georgia they have a code commission, just like our code committee, and they said because the commission in Georgia was involved with it and they supervised the annotations, that it was in effect the legislature, and so it was the legislature doing the copyright with contract with Lexis, but it had it was considered to be a public body doing it. What Anders has said is they actually vote not on the annotations really per se, but they vote on merging the annotations into their code, and y'all don't do that. So, but what he wants to do, he and I talked about it this morning, is maybe in the contract soften it somewhat where it makes it appear very clear that y'all are not doing the annotations, in case it ever comes up that we got sued. I think they're going to continue on the way they are. they'd have to evaluate it if they're losing revenue because people are copying and reselling their product. But anyway, that's what he would be doing is changes to the code where, I mean, to the contract where it's not saying that they supervise the annotation. Maybe that we contract with them and they just do it. We're not supervising and we're not coming back and approving them, which you're not anyway. So, for Mr. Speaker, you and Representative Reynolds had heard about this as it went through the courts. We were all shocked that it was a 5-4 decision. We thought it was pretty clear that they could copyright their own work. And maybe we still can in Mississippi, for the Mississippi Code. Georgia the legislature was a lot more involved in their annotations than we are.
Is there any action we need to take today on this?
No, sir.
Okay, it's just for information only.
Yes, yes. Okay, and we wanted to let you know, because
Anybody-
Anders may present something at the next year's meeting based on this, so.
Okay. Anyone have a question about any of that? All right, thank you, Anders. I think that concludes our business. Is there any other business to come before this committee today? Ronnie, I want to thank you and Ian for your hard work. I know this is tedious. I know it's time consuming, but it is critically important. This is the final safeguard, if you will, against the code being printed, and whatever's put out there is what the rest of the world sees that this legislature has done. So it's very important that we get it right, and these two guys spend a lot of time doing that. I trust their judgment and trust their work, and I appreciate the dedication they have to making sure this is done right. I want to thank each of you committee members for being here today, making sure this is done right. As I said, this is critically important that we get it right. So with that, I'll entertain a motion to adjourn. And I have a motion. All in favor say aye. Opposed, nay. The ayes have it. Committee is adjourned.
Good to see you again, Tommy. Like I said, we used to be on a lot of committees. No, did you?